So welcome. I am Karen. I am the chapter chair of Dying with Dignity Edmonton. I got involved a long time ago. I've probably been volunteering with the group since 2015, I want to say. Um, just always been a strong supporter in bodily autonomy. I've always been fighting for pro-choice activism, that kind of thing. So this just was an extension of that. And then as life went on, my mother received MAID nearly 3 years ago due to stage 4 cancer, and my father is actually set to take MAID in about 3 weeks from today. So lots of experience with it that I didn't realize when I started volunteering that I would end up having, but that's just the way it goes, I guess. I do want to start off with a land acknowledgement. We do acknowledge the traditional lands and territories of the Indigenous peoples who have lived on these lands and have taken care of them since time immemorial. What became known as the province of Alberta in 1905 is also the traditional and ancestral home to many Indigenous peoples, and for that we are honored to have shared this land with them since Treaties 6, 7, and 8 were entered into. We acknowledge the many First Nations, Métis, and Inuit who have lived in and cared for these lands for generations. All right, we're going to get started here. I'm going to turn off my video because it does distract me to see myself on screen sometimes. So I am going to do that. And I'm assuming that everyone can see the presenter view up on the screen okay? Thumbs up if you can. Perfect. Okay. So disclaimer time, the information provided is accurate as of this presentation date, which is an interesting date because today we have Bill 18 on the docket for the Alberta legislature, and it's their third reading, so it might actually pass today, which means some of the information I'm giving you might be a few hours out of date, but I will try to discuss some of the differences between what that bill would mean for us in Alberta if it passes. So the material is in this presentation is provided for information only and should not be considered healthcare, medical, or legal advice. It's not intended to encourage or suggest to anyone that they should choose MAID. I'm not a doctor, I'm not a lawyer, I'm a volunteer who has just been trained and given information, so I'll try my best to answer some questions, but I won't be able to answer everything, especially if it's a health consideration or things like that you might need a doctor. So if you require advice or counsel, you should have questions regarding medical or legal matters, you need to contact the appropriate licensed professional. So Dying with Dignity Canada is a national human rights charity committed to improving quality of dying, protecting end-of-life rights, and helping people across Canada avoid unwanted suffering. We defend human rights by advocating for assisted dying rules that respect the Canadian Constitution and the Charter of Rights and Freedoms. We provide support to adults suffering from a grievous and irremediable medical condition who wish to die on their own terms. We educate people across Canada about their legal end-of-life options, including the constitutional right to medical assistance in dying and the importance of advanced care planning. Most major cities have a chapter. There are currently 12 active chapters across Canada, and the chapters are run entirely by volunteers who are dedicated to our mission. The Edmonton chapter also works closely with the Calgary chapter as a joint committee because we face a lot of the same challenges. We hold online and in-person events, give presentations locally, and offer support for witnessing request forms. I'm going to start off with the background of medical assistance in dying in case you don't know when it became legal or how it became legal. So I want to remember the people who've made history in our country. Sue Rodriguez is the top left picture there. She was diagnosed with ALS and ultimately made the decision to end her life. She sought the assistance of a doctor, but at the time it was illegal under Canada's criminal code, leading to a legal battle in 1993. She lost her case in front of the Supreme Court of Canada in a vote of 5-4 and took her own life by ingesting a liquid mixture that was given to her by the help of an anonymous doctor in February of 1994. An investigation was undertaken, but no charges were laid. We fast forward to over a decade later, and there was another court case. This time, it was the family of Kay Carter, who is in the top right. a woman suffering from degenerative spinal stenosis, and Gloria Taylor, just below her in the middle right, a woman suffering from... Oh, I'm saying that the slides aren't advancing. Okay, let's see what we can do here. That's strange. So you guys still have my chapters or just my Dying with Dignity slide showing up? There, is that changed now?
Okay.
Yeah, that's
Okay. I think I need to have both. I just got my presenter view open, but apparently I need to have both of them open for it to work. All right, so the chapters one is literally just a picture of Canada, so you didn't miss anything on that slide, but this one has the pictures. So Sue Rodriguez is up in the top left, and then we've got Kay Carter on the top right, and we were talking about Gloria Taylor now in the middle right. So she was suffering from ALS. This was first challenged in BC, then it went to the Supreme Court of Canada in an appeal in 2015. In a unanimous decision, the court struck down the provision in the Criminal Code, thereby giving Canadian adults who are mentally competent and suffering intolerably the right to a doctor's assistance in dying. This ruling overturned the Supreme Court's original 1993 ruling against Rodriguez. The ruling allowed the government a year to implement a new law, and medical assistance in dying became legal in 2016. Neither Kay Carter nor Gloria Taylor survived long enough to see the ruling from the Supreme Court. Kay Carter actually went to Switzerland to have an assisted death, and so she didn't live long enough to know the ruling, and Gloria Taylor died from her illness before the ruling happened. Price Carter, Kay Carter's son, who was instrumental in bringing the case to the Supreme Court, accessed MAID himself in 2025 after a diagnosis of pancreatic cancer. In September of 2019, we then have another court case, the applicants being Jean Truchon, who is the bottom left. He had cerebral palsy, and Nicole Gladue, who's the middle left, who suffered from post-polio syndrome. They argued that their suffering had reached a point that was intolerable, but both had been denied MAID under existing laws because they were not considered to be near the end of their natural lives. They challenged that law, arguing that the eligibility requirements for MAID infringed upon their rights to life, liberty, and security of person, and equality rights under the Canadian Charter of Rights and Freedoms. The Truchon-Gladue decision in the Superior Quebec Court ruled that the requirement that death be in the foreseeable future was unconstitutional. Neither Quebec nor the federal government appealed this decision. As a result, in October of 2020, the Minister of Justice and Attorney General of Canada introduced Bill C-7, which was an act to amend the Criminal Code and proposed changes to Canada's law on medical assistance in dying, and created what we know now as Track 2 MAID. Jean Truchon died in 2020 using MAID after the 29 decision in his favor. Nicole Gladue died from natural causes. In 2016, we have Audrey Parker, who's the bottom right. She was diagnosed with breast cancer, which eventually became stage 4 and started moving to her brain lining. She had been approved for an assisted death, but she feared that she would lose capacity before her chosen provision date and lose the opportunity to die on her own terms. Because of this flaw in the legislation, Audrey chose to die earlier than what she wanted, but her courage to speak out impacted change. 3 days before she died, she recorded a video in which she stated, "My last wish is that you, my fellow Canadians, that you will help people who have been assessed and approved for medical assistance in dying to live without fear of their rights being taken away." So in March of 2021, Bill C-7 was passed, and the waiver of final consent was made legal in Canada's MAID legislation. It's often referred to as Audrey's Amendment. A waiver of final consent allows the patient to pick a date in the future that MAID can proceed even if the patient loses the capacity to consent at the time. You do have to have capacity in order to sign the waiver, and you still have to have capacity on the day the waiver I'm going to start that sentence again because I've read it all backwards. You do have to have capacity in order to sign the waiver, and if you still have capacity on the day the waiver states, you can pick a new date and sign a new waiver. This is only available through Track 1, which we're going to discuss on a later slide. I've actually met someone through a support group whose partner is on their 6th waiver. So a quick recap. February 2015, we have the Supreme Court Canada ruling in Carter versus Canada that changed the criminal code, and they gave the government until June 6th of 2016 to create the new law. 2016, the Parliament of Canada passes the federal legislation that allows eligible Canadian adults to request medical assistance in dying. 2019, we have the decision out of Quebec that sets the road for Track 2 MAID. March of 2021, there's revised legislation that allows for changes to the medical assistance in dying process of assessment, which opened up the doors for Track 2. 2023, we have a report from the Joint Parliamentary Committee. This was required by Bill C7 that dealt with recommendations on mature minors, advance requests, and mental illness as the sole underlying condition. March of 2024 was originally set as the date that persons with treatment-resistant mental illness could have access to MAID, but that was kicked down the road, and it is now due March 2027. The reason for that delay was that they wanted to ensure the safeguards were going to be robust enough. MAID eligibility in Canada. So who is eligible? You must be 18 years of age. You must have a grievous and irremediable medical condition, which includes a serious and incurable illness, disease, or disability. You must also be in an advanced state of irreversible decline and must be experiencing intolerable suffering caused by your ailment. You must have capacity when you sign your record of request and during the assessment process, and for your waiver of final consent if you are considered Track 1. Track 2 patients need to retain capacity throughout the process, including up until the moment before provision. So they may have to take MAID earlier than they would want. Don't worry, we're going to go into detail about Track 1 versus Track 2 shortly. Your natural death does not need to be reasonably foreseeable, which we will also discuss in future slides, and mental illness cannot be your sole underlying condition until next year. Safeguards. The request cannot be done by your agent on your behalf. A lot of people seem to think that this is a possibility, but it's not. Only you yourself can request MAID. You will first fill out a record of request form, which will be signed by an independent witness. So this means someone that is not listed in your will and someone over 18 years old. This does not guarantee that you will receive MAID. It is a first step in order to see if you qualify. You can have your doctor or nurse practitioner send it in for you. You can fax it to the local care team if maybe your doctor doesn't want to be involved, or mail it to the care team yourself. All the relevant options are listed in detail on the form. 2 independent practitioners, a doctor or a nurse practitioner, will then assess your condition to see if you are eligible. They review your medical chart prior to meeting with you and have a lengthy discussion with you regarding your medical history during these meetings. Independent means it's someone other than your own family doctor, someone that doesn't know you. If you are deemed eligible, you will be classified into one of 2 categories. If your death is reasonably foreseeable, you will be considered Track 1. Otherwise, you fall into Track 2. And we're going to discuss these different tracks. The core criterion for Track 1 is that the individual's natural death is reasonably foreseeable. This typically applies to individuals with a terminal illness, but can also include those with a prolonged illness where death is clearly approaching. Originally, there was no set time frame for this, and doesn't mean specifically that death is within a few months. If you have a life-limiting disease, it is reasonable to expect death is coming, even if it's more than a year away. We have even had a court case that helped clarify this. Out of Ontario, it's called AB versus Ontario. In a 2017 case, the judge upheld that the physician need not opine about the specific length of time that the person requesting medical assistance in dying has remaining. While AB versus Canada is not binding on Alberta law, as the case took place in Ontario, its reasoning has been adopted by regulatory bodies in other provinces. However, it is ultimately down to this assessor to determine what they think reasonably foreseeable means. They may, as I saw with my father, do more research on the trajectory of your disease to make this determination. If Bill 18 passes, legislation tabled just March 18th of this year and due for its third reading maybe even this afternoon, reasonably foreseeable timeline is going to be limited to 12 months for Alberta cases. There are 2 independent assessors, so this is an approval from 2 independent assessors to ensure that you're eligible. If Bill 18 passes, the assessors will also be required to discuss your history with all primary care involved in your case in the past 12 months. Track 1 can request MAID provision more immediately once they meet the eligibility. There is no wait period, so if you are maybe like my mother, she actually was given a week to live because of complications with her disease, and she actually ended up taking her MAID provision within 6 days of putting in the request form, so there is no wait period there. The waiver of final consent. Individuals in Track 1 are also eligible to complete this, but it's only for Track 1. My mother, again, also used the waiver of final consent. She had a complication of blood clotting and bleeding out, so she may have lost consciousness at any time from a stroke or from a brain bleed. So she chose her date, and if she had lost consciousness prior to that, then the practitioner would have been able to go ahead and give her MAID. She didn't need to use it. She was able to sign the final form. Track 2 differs because this is for individuals still with a grievous and irremediable condition whose natural death is not reasonably foreseeable. So progressive diseases where capacity may be lost in later years, chronic illness or disability that's reached a point of suffering that the patient no longer finds acceptable, these types of situations fall into this category. You still have the 2 independent assessments, but there are also enhanced safeguards for Track 2. It requires a minimum 90-day assessment period. So it's like a cooling off wait period. And in that time, you need to have an expert consultation, someone that's an expert perhaps in the condition that you are living with, and detailed information about palliative, home care options, and treatment options. Under this track, a waiver for consent is not available. You must retain capacity until the moments before your provision. I want you to note that after Bill 18 passes, this will no longer be an option. Track 2 will no longer be available in Alberta. We're going to do some boring stats, but I think some of it's important and sometimes answers questions that people might have. This shows deaths using MAID as a percentage of deaths in Alberta. To some, the chart might seem scary because it looks like MAID deaths are increasing. In Alberta, our percentage of deaths sits just under 4% for MAID. MAID deaths make up 4% of all deaths in the province. In Canada as a whole, that number is just over 5%. For years, critics of MAID in Canada have pointed to rapid year-over-year increases as proof that the system is spiraling out of control. But the data now shows the opposite. Growth is slowing predictably and consistently, just as we would expect from any new practice. These numbers increased because of more acceptance or knowledge that the process is legal, and information about MAID and how to access it is more readily available. I want to make it clear that those accessing MAID are still overwhelmingly in the Track 1 category, which means their deaths are foreseeable. This also means using Track 1 that their condition cannot be reversed, we cannot cure them, we cannot stop their death. MAID simply lets them take control over the type of death they have. More people die with dignity. The most recent report we have from 2025 gives the numbers Canada-wide from the year prior. Overwhelmingly, most MAID cases are in Track 1. The chart on the right, the pie chart, shows all deaths in Canada. In 2024, there were approximately 322,000 deaths in Canada, and of those, just over 5% involved MAID. Track 2, whose deaths are not reasonably foreseeable, that little orange line on the pie chart and represents less than half of 1% of all deaths. This chart shows the primary reasons someone may request MAID. I want you to note, though, some categories overlap because some people don't just have one condition. So many people have multiple conditions. So don't try to add them up because they won't add up to 100. It will be more than that. Cancer is still the leading reason that people request MAID on track 1. Other reasons are cardiovascular, respiratory, and other conditions such as ALS and organ failure. Track 2 is quite a bit more complicated as people have complex conditions with multiple issues causing significant decline across multiple body systems. So there is a little list on the side of some of them. They all kind of get lumped into what's called other. We also see a large number of neurological diseases such as MS, Parkinson's, or Huntington's disease. In some of those types of diseases, a dementia component is of concern. Many fall into track 2 because their death is not reasonably foreseeable when they are requesting MAID, but they're choosing it early to avoid that lack of capacity that happens in the later years. The average age group for track 1 is 78 years, while the average age group for track 2 is 76 years. Demographics are pretty even between men versus women. We do face some barriers to access. Current institutional barriers, some facilities do not allow MAID on site. Some faith-based institutions, for example, like Covenant Health, and that leads to what we call either forced transfers or religious obstruction. You might see both those words. Alberta has a public system that is run by 2 different entities, one allowing for MAID provision on site, while the other does not. Patients are forced to transfer out of the hospital they are in to receive this provision elsewhere. Unfortunately, some may not be able to be moved because of the severity of their condition and therefore cannot access MAID. This does have broader system factors. MAID is not considered a component of palliative care in Canada, despite the fact that most people who do access MAID are also receiving palliative care. Those receiving palliative care in a facility that does not allow for MAID will have to overcome extra barriers. In January of 2026, Dying with Dignity did do a more recent poll of Canadians. It showed that 85% supported existing legislation, 82% support Track 2 MAID, which is actually up from 78% in 2023, and 82% of Canadians support future changes to legislation for advance requests. What's an advance request? It's not the same as your advanced care plan or your personal directive. Sometimes you see advanced directive, depends on what province you've come from. Different words get thrown about and a lot of people get these confused. Advance requests speak specifically to people diagnosed with dementia or a disease involving dementia in the later stages. Quebec is currently the only province in Canada that has moved forward with advance requests for MAID. Didn't happen overnight. It was a multi-year process involving public consultation, expert input, and legislative change. This started with a special commission in 2021 where Quebec actively consulted the public and experts about expanding MAID. What's important here is this wasn't rushed. There was a strong public engagement and advance requests were already being discussed as a future need, especially for conditions like dementia. In 2022, the Commission released its report recommending positive changes, including allowing advance requests. So at this point, it moved from discussion into a formal recommendation. In 2022, Bill 11 was introduced to allow advance requests. This is a key moment because the government is now acting on those recommendations and advance requests became a concrete policy proposal. In March of 2023, the bill was reviewed and unanimously adopted by the Public Health Committee. It's significant because it shows cross-party agreement. This wasn't a divisive issue at the committee level. In June of 2023, the National Assembly passed the bill 76-0. There was strong political consensus. Advance requests were seen as a reasonable and necessary evolution of MAID. It shows us that the advance request Quebec were carefully studied, publicly consulted, broadly supported, and implemented through a structured process. This is important when we think about what's happening in Alberta because it shows another Canadian model already exists. Quebec's created a pathway for people to plan ahead for those with conditions like dementia, while other provinces like us are moving in a different direction. So on October 2024, Quebec moved forward with advance requests. Canadian Federal Health Minister Mark Holland said that Ottawa would not be contesting Quebec's law. He also said that criminal charges for MAID are overseen by provincial law enforcement, so advance requests are still considered an offence according to the criminal code, but the province of Quebec has instructed its prosecutor's office not to charge doctors or nurse practitioners who provide MAID via an advance request. The federal government then launched a national consultation on advance requests between 2024 November and February of 2025 with a report that was due to be published last fall, but we're still waiting on it. So we'll see what happens. The future of MAID in Canada. In 2021, when Bill C-7 was adopted in response to that Truchon decision, I did say that Parliament stipulated that a joint committee be established. So they were to study 3 questions: mental illness as a sole underlying condition, advance requests, and mature minors. The Special Joint Committee on Medical Assistance in Dying was a mix of members of Parliament, so MPs, and senators from multiple political parties, and it was intentional to reflect a broad national perspective. Alberta did have an MP included. It was the local St. Albert MP, Michael Cooper. Mental illness as sole underlying condition is set to become legal in March of 2027, and as I mentioned, a new parliamentary committee has been created to study the extra safeguards that are going to be put in place for that. The original committee recommended that advance requests for MAID be allowed in Canada, not yet been implemented. Mature minors was also a recommendation from the last committee report in the context of Track 1. There has been no further movement on that issue either. The local MP that was on the committee the first time round, Michael Cooper, did not support the main committee recommendations, including on advance requests. He was part of a group that formally dissented from the report. And there is now a new joint committee that's working towards making sure the safeguards in place for March, when mental illness will be included, are robust enough. Michael Cooper is again on the committee, and we also have Alberta Senator Christopher Wells as part of that committee as well. I do want to note, if Bill 18 passes, possibly this afternoon, advance requests and mature minors will not be allowed in Alberta, even if they become legal federally. It will also ban MAID for those whose sole medical condition is treatment-resistant mental illness, even when this federal exemption is lifted in March. A couple of questions we get asked fairly regularly is who can provide MAID. So it's a nurse practitioner or a physician that will give you the provision. Where can I receive MAID? At home? In a hospital? Some people do it in their backyard. I don't think you're very limited, other than it obviously can't be out in public. Covenant Health does not allow MAID in their institutions though, so please bear that in mind. How does MAID happen? It's assisted or self-administered. Overwhelmingly, people choose to have the assisted version. Self-administered is a little bit more like what Sue Rodriguez did. It was a liquid mixture that is swallowed and usually is taken with anti-nausea meds, but there was only about 5 cases across all of Canada that were self-administered in 2024. The assisted version has drugs being given to you via an IV that make you sleepy and then to stop your heart. Alberta Health Services gives access to a single point of contact for all end-of-life options, including medical assistance in dying, through a team called the Kerr Coordination Service. You search the Alberta Health Services website by searching for medical assistance in dying, and you'll come on this page. You can also email the MAID Care team, and I've got their email at the bottom there, or call 811 and they will direct you to the right people. Under the Patient Family Member section, you will find answers to frequently asked questions, as well as a link for the request form. Dying with Dignity can help you if you're unable to find a witness for the request form. We do have volunteers who have to go through screening, police screening, for vulnerable sector, and they can help you if you need that. Please note, Bill 18 creates a care coordination team under the Alberta Minister of Justice, and we don't know yet how this will affect accessibility or providers. I know a recent poll by the Alberta Medical Association regarding Bill 18 was just completed a few weeks ago, and Bill 18 would make about half of the current MAID assessors and providers less willing to assess eligibility, and about 5% have said they will stop providing MAID altogether. There's a couple of extra considerations depending on your situation. A lot of people think if they receive MAID, they can't be an organ donor. You can't be an organ donor if you have active cancer at the time of your death, but not all diseases preclude organ donation. So each case is evaluated individually, and the medical team considers the overall health of the potential donor. Even patients who receive MAID may be eligible to donate organs or tissues, if that's something you would like to do. Can be discussed with the doctors who will assess you, and they'll be able to tell you if you qualify. Just want to note though, if you do want to donate organs and you are deemed eligible, you do have to receive MAID in a hospital because organ donation is very time sensitive. If you wanted to do something like donate tissues such as corneas, whole joints, or skin to help burn victims, the process needs to be completed about 15 to 20 hours after death, so you're not required to be in a hospital for those situations. Another option is that you can donate your body to the Anatomical Gifts program, which is via the Faculty of Medicine and Dentistry, where they obviously use the body then to teach courses in human anatomy, medical, dental, do extra studies, things like that. So these are options if it's something you feel passionate about. You have to arrange and ask for them. You do not have to sign up to be an organ donor to receive MAID. That is a myth. Going to quickly talk a little bit more about Bill 18, just so you're aware of what this legislation will do. Obviously, most of our information is based on what the Canadian law is, but the Bill 18 Safeguards for Termination of Life Act was introduced on March 18th and looks to be passed at some point this week. This means MAID looks different in Alberta from the rest of Canada. So it prohibits Track 2 MAID while also limiting Track 1 MAID to a 12-month window. It states that a practitioner may only provide MAID if the individual's natural death is reasonably foreseeable within 12 months of the date of the opinion, which means assessment. As we discussed earlier, under Canada's federal MAID law, there's no specific timeline limit associated with Track 1 MAID. This creates an added challenge for Alberta patients and clinicians to navigate, as prognosis can be uncertain. Lots of conditions like ALS, heart failure don't always follow the same trajectory depending on who has them. So by limiting that definition to reasonably foreseeable to 12 months means that some individuals living with dementia or other capacity diminishing conditions like Huntington's disease, they're going to lose capacity prior to meeting that 12-month requirement and will no longer be able to access MAID at all. Without Track 2, there's not really any other pathway. This also allows for organizations to choose if they allow MAID and MAID assessments on their premise with a 150-meter bubble zone around them. This permits healthcare facilities to create this exclusion zone. 150 meters is pretty big. It's a football field and a half, or almost a full block. So you're not even going to be permitted to have an assessment for MAID or have MAID paperwork witnessed on the sidewalk outside an objecting hospital, for example. It's also going to prohibit advance requests, so it closes the door for advance requests even if those become legal federally. The bill also requires a family member to be present as a witness during MAID provision. Practitioners will be asked to contact family members even if they're aware of harmful factors. Maybe you've had an abusive family or you're estranged. Family members do have the option to opt out of this role, and if the requirement so it's not applicable if the practitioner is also of the opinion that there's no family member who's reasonably available to act as a witness. So if you moved here from a different country and all your family live in a different country, then that can be waived. It prohibits out-of-province referrals. This has real implications for those that may have been approved under Track 1 by the federal standards, but no longer fulfill the 12-month reasonably foreseeable death, and for all Track 2 patients who can no longer access that in our province. You will not be able to get a referral from your doctor for a different jurisdiction, a different province. You're going to have to navigate that on your own, unfortunately. Bill 18 also puts restrictions on information, as providers are restricted from initiating MAID conversations. It requires assessors to contact all your primary care providers for the past 12 months, which can obviously cause delays in your approval. And Bill 18 also creates a new care coordination team under the Alberta Ministry of Justice. We do not know yet how this will affect the current MAID care coordination team or its providers. Thank you. I know that was a lot of information, but I want to open up the floor to questions, and hopefully I know some of the answers. I've also got the MAID care team and our email addresses down at the bottom there for you. So, okay. Any questions? Let's see if I can stop sharing here so I can see people.
A few hands up in this room.
Perfect.